Okay, so you ever find yourself like watching one of those legal dramas on TV
Oh, yeah.
and like wondering how those psychological evaluations actually play out in real life?
All the time.
Like,
Wow.
how does it work when, like, what someone thinks about, the way the mind works,
Right.
bumps up against, like, the very strict rules of the legal system?
Absolutely. Yeah.
I think that's fascinating, and that's what we're going to dive into today.
I'm excited.
Forensic psychology. And we're
Yeah.
really going to look at the guidelines and legal principles
Right.
that kind of shape this whole really interesting area.
It is a really unique space, where you have these like super nuanced
Yeah.
aspects of human behavior.
Yeah.
And then they have to fit into like a system that's often, very black and white.
Absolutely.
Sure.
Yeah. Yeah. So we want to go beyond just like what you see, in headlines or
Yeah.
on TV shows and really give you a solid understanding of what forensic psychology is all about. We'll be looking at the roles that psychologists play in legal cases,
Uh-huh.
the ethical stuff that guides their work,
Yeah.
and honestly, some of the surprisingly specific rules that they have to follow.
For sure.
We're going to be drawing from some really interesting sources for this.
Okay.
Professional guidelines from the APA.
The American Psychological Association.
Exactly. And then legal codes specifically from California.
Oh, interesting.
Yeah. So we can kind of get like a really well-rounded picture,
I like it.
from like these broad ethical principles
Yeah.
down to the like very nitty-gritty legal stuff
Perfect.
that they deal with.
Love it.
So to kick things off, I think we got to start with like a super important distinction
Okay.
that kind of lays the groundwork for a lot of what we'll be talking about.
Right.
And that's the difference between
Mm-hmm.
an expert witness and a fact witness.
Oh, yeah. These are different.
They sound similar,
Yes.
but they are totally different when it comes to what they do in court.
Yeah, so we have some definitions from our sources. Okay. One of them defines an expert witness, and it's referencing Kucher's work here.
Okay.
It says an expert witness is someone who brings, quote, special training knowledge, skill, or experience
Okay.
in an area relevant to the resolution of the legal dispute,
Got it.
and who is allowed to offer an opinion as testimony in court.
So basically, like, if there's a case and to really understand what's going on,
Yeah.
you need to understand something like,
Uh-huh.
long-term trauma
Right.
and how that affects somebody's behavior.
Right.
You would have an expert witness, a psychologist who knows a lot about trauma,
Exactly.
who can, like, explain it all.
Yeah, give their professional opinion about how trauma connects to this specific situation.
Yeah, and, like, translate it for everybody else.
Yeah, they're bringing in that specialized knowledge that, like, most people wouldn't know,
Right.
right, to help the judge and the jury understand these, like, really complex issues.
Okay, cool. So then what about a fact witness?
Right, so a fact witness is different. The APA defines a fact witness as someone, quote, who testifies as to what he/she
Okay.
has seen, heard, or otherwise observed regarding a circumstance, event, or occurrence as it actually took place.
Okay.
Fact witnesses are generally not allowed to offer opinion-address issues that they do not have personal knowledge of
Oh.
or respond to hypothetical situations, end quote.
I see. So a fact witness is more like just reporting?
Yeah, think of it like they're just saying what they experienced
Okay.
that's connected to the case.
Yeah.
So, like, let's say a therapist just happened to see something.
Okay.
That's part of a legal fight now.
Yeah.
They would talk about what they saw and heard, but they wouldn't,
Give them professional opinion.
right, they wouldn't give interpretations or anything like that.
Okay.
Unless, of course, they were also qualified to be an expert witness and they were asked to be one.
Okay, so this is where things get kind of interesting.
I was going to say, this is important for, like, anyone who's ever been to therapy.
Right.
Our sources are very clear that if a psychologist knows something about a client,
Uh-huh.
which could make them a fact witness,
Right.
they can only share that information in a legal case
Okay.
if they have the client's permission to do so,
Okay.
or if a court orders them to.
That makes sense.
Yeah, it shows how important it is to protect someone's privacy
Yeah,
and their right to make choices about their therapy.
absolutely.
The legal system recognizes that that relationship is really sensitive.
Okay, so building on that, let's talk about privilege and confidentiality
Okay.
when it comes to forensic settings.
Yes, this is big.
So in general, psychologists have this really strong ethical obligation
Right?
to keep the information they learn about their clients confidential.
Absolutely. It's like a cornerstone of the profession.
Right.
Yeah, and paragraph 8 of the specialty guidelines for forensic psychology
Oh.
really emphasizes this. It says that forensic psychologists, quote, recognize their ethical obligations
Uh-huh.
to maintain the confidentiality of information relating to a client or a retaining party, except insofar as disclosure is consented to by the client or retaining party or required or permitted by law.
So there are some exceptions to that.
Right, like with most things where law and psychology meet, it's not always simple.
Right.
There are specific situations where that privilege doesn't apply.
Okay, so for example,
Right.
California Evidence Code Section 1016 says that if someone's emotional condition becomes part of a legal case,
Like they're claiming emotional harm or something?
exactly, then that privilege can be waived.
Yeah, it makes sense. The court needs to be able to consider
Right.
all the relevant information if someone's saying they've been emotionally harmed.
Right. So it's kind of like by putting it out there,
Right.
you're opening the door.
Exactly. Their actions within the legal process directly affect how private their psychological information is.
Okay. And then another exception is.
Oh, yeah. We see this with court-ordered evaluations.
Okay.
And Evidence Code Section 1017 talks about this.
Okay.
So if a judge orders a psychological evaluation, like to decide if someone's competent to stand trial
Right.
or if they were sane when a crime happened,
Okay.
the usual therapist-patient privilege doesn't really apply.
So the main goal there
Is
is.
to get information to the court.
Right.
It's not about, like, building a confidential therapy relationship.
Okay.
The point is to give the legal system an objective assessment.
That makes sense.
Yeah. And that's why it's super important for psychologists to tell the person being evaluated
Uh-huh.
what the evaluation is for
Okay.
and what the limits are on confidentiality.
Right. So it's like a different situation than going to therapy.
Totally. It's important to understand that.
Absolutely. And that brings us to another point.
Okay.
Paragraph 6.03.02 of the specialty guidelines.
Okay.
This talks about situations where someone's ordered by the court to get treatment,
Uh-huh.
but the goals of that treatment are set by, like, a legal authority.
Right. Not necessarily the person in therapy.
Exactly. So in those cases, the psychologist has to explain everything.
Yeah. What a treatment's about. The purpose, and really important, any limits on confidentiality and privilege.
So it's a very different dynamic than, like, seeking therapy on your own.
Yeah, for sure. When therapy is required by the legal system, it changes things.
Right.
And the person needs to know that what they talk about might be used in court.
Right. And how about when it comes to, like, teaching or research
Oh, yeah. Good.
and using case materials for that?
Our sources talk about that, too.
Okay.
Paragraph 8.04 of the specialty guidelines says it's super important to present that information in a way that's fair, balanced, and respectful,
Yeah.
and always protecting the privacy of the people involved.
Right.
So usually that means changing identifying details,
Uh-huh.
only using info that's already public, or getting consent if they need more specific stuff.
There's, like, a balance.
Totally.
Right.
The field needs those real-world cases to learn and grow.
Right.
But you can't do that at the expense of someone's privacy.
Yeah, you can't forget about the people.
Exactly.
Okay, so Standard 3.1c of the Ethics Code. This one further emphasizes this whole idea of informed consent.
Right.
So it says that when psychologists are providing services because a court ordered it,
Yeah.
they have to tell the person about what those services are and any limits to confidentiality before they start.
Makes sense.
Yeah. So for instance, a psychologist might have to tell the court if someone showed up for therapy.
Right. Like if it was court mandated.
Exactly. And in most cases, they'd need permission from the client
Okay.
to say anything more than just whether they were there or not.
Interesting. So even something like just confirming if someone attended or not
Right.
still falls under those rules about confidentiality and informed consent.
Yes, exactly.
Huh?
Okay, so let's dive into informed consent a bit more,
Right.
specifically with forensic examinations.
Right.
So paragraph 6 of the specialty guidelines tells us that psychologists
Yeah.
want to make sure people understand the what and the how.
Right. The nature and the scope of the services. Yeah.
Exactly. And paragraph 6.01 says they should give that info as soon as possible.
Informed consent is so important. It's like the foundation.
Right.
People have the right to decide about participating in an examination,
Yeah.
especially when the results could really affect them legally.
Absolutely.
Mhm.
So unless a court has specifically ordered the examination,
Right.
psychologists usually have to get informed consent before they can do anything.
Okay.
So then what happens if someone understands everything about the exam
Uh-huh.
but chooses not to do it?
Well, paragraph 6.03.01 tells us what the psychologist can do in that situation.
Okay.
They could postpone it.
Okay.
Advise the person to talk to their lawyer,
Mm-hmm.
and let whoever requested the exam know that the person refused.
Okay.
It's all about respecting that person's right to choose, even in a legal setting.
Makes sense. So, but if the exam is court ordered,
Then things change a bit.
Okay.
Paragraph 6.03.02 says the psychologist can move forward
Mm-hmm.
even if the person objects or doesn't give consent.
So because the court said so.
Exactly.
Yeah.
But even then, if the person just refuses to participate,
Yeah.
the psychologist might still suggest talking to a lawyer
Okay.
and notify the people who requested the exam.
Okay.
There's still that effort to engage and inform.
Right, even though they don't technically need consent.
Right. It's about respecting the person as much as possible within the court's order.
Yeah, I see that. And then there's the situation where someone might not be able to give informed consent.
Right. Like if they're too young or have cognitive issues.
Exactly. So paragraph 6.03.03 says the psychologist needs to explain things.
Yeah, in a way the person can understand.
Okay.
Get their agreement, if possible.
Okay.
And get permission from a legal guardian or someone like that.
Okay.
It's all about protecting people who might be more vulnerable
Right.
and making sure decisions about their involvement are made responsibly.
That makes a lot of sense.
Okay.
Okay, so let's move on to something that comes up all the time.
Okay.
In this area where psychology and law meet,
Yeah. What's that?
the insanity defense.
Oh, yeah, that's a big one.
It is, and it's important to know right from the start that insanity is a legal term.
Yeah, it's not a diagnosis.
Right. It's not a psychological or medical thing.
Exactly. A psychologist can look at someone's mental state
Right.
and how they function, but whether they're legally insane or not,
Mhm.
that's up to the legal system based on their specific rules.
Right. And our source material mentions this thing called the American Law Institute rule.
Oh, yeah, I've heard of
Yeah.
that.
And it gives us kind of a general framework.
Uh-huh.
And it suggests that a person isn't criminally responsible
Mhm.
if,
Okay.
because of a mental problem, they couldn't understand that what they were doing was wrong,
Okay.
or they couldn't control their actions.
So, two possible reasons for an insanity defense.
Yeah, either they didn't get it or they couldn't help it.
Interesting.
But California has its own specific legal standard.
Okay.
And this is in Penal Code Section 25B.
Right.
So here, the person accused has to prove by a preponderance of the evidence.
Meaning it's more likely than not.
Exactly, that when the crime happened, they couldn't understand what they were doing.
Okay. And they couldn't tell right from wrong.
And it's in both of those.
Yeah, both have to be true.
So that's a pretty high bar.
Right. It's not enough to just have a mental illness.
Exactly. It has to directly connect to them not understanding their actions.
Yeah. Or not knowing right from wrong at the exact moment it happened.
That's a lot to prove.
And then California Penal Code Section 25.5
Okay.
makes it even more clear what does not count
Oh, interesting.
for an insanity defense on its own.
What kinds of things?
Things like personality or adjustment disorders, seizure disorders, and being intoxicated or addicted to drugs or alcohol.
Okay. Unless those things caused a separate, qualifying, severe mental problem.
Right. So just having one of those things.
Doesn't automatically mean you have an insanity defense.
No.
It has to be more than that.
Yeah, it has to seriously affect how you understand things
Okay.
at the time of the crime.
Got it.
So the legal definition of insanity,
Yeah.
it's very specific. It's a legal thing.
Yeah. And it's different from how we might use the word insanity normally.
Everyday language.
Right. It's a strict rule.
Right.
That really zeroes in on the person's mental state at that moment.
Yeah, when the crime happened.
Exactly.
It's interesting how the legal system takes these psychological concepts,
right.
but then it kind of redefines them for its own purposes.
To fit in with its own system.
Right.
Okay. So last but not least, let's talk about subpoenas,
Right.
which are these formal legal demands that psychologists might have to deal with.
Okay.
Kuchar defines a subpoena as, quote, a court document requiring a person to appear,
Okay.
to give testimony at a deposition or in court.
Okay.
And a subpoena, duces tecum, that's a mouthful,
Right.
means they have to bring specific documents or records with them.
Okay, so basically they have to show up and bring their stuff.
Exactly. And it's important because it forces people to give information or evidence in legal cases.
Okay, so who can issue a subpoena?
Well, it depends. But usually it's judges, court clerks, or attorneys.
Okay, so if a psychologist gets a subpoena, yeah, the APA has some guidelines for what to do.
Okay, good, because that sounds like a tricky situation.
It can be.
Okay, so what's step one?
The very first thing is to make sure the subpoena is legit.
Okay.
Is it from the right authority? Was it served properly? Stuff like that.
So don't just hand over everything right away.
No. The next step is to talk to the client
Okay.
and explain what disclosing this info could mean for them.
Okay.
If the client says yes and there's no reason to hold back,
Mm-hmm.
like if there are worries about the client's safety or if the information is super sensitive,
Right.
then the psychologist can give the requested information.
Okay, but what if the client doesn't want them to share anything?
Right. Then it's time to negotiate.
Okay.
Either the psychologist or their lawyer can talk to the people who sent the subpoena,
Mm-hmm.
see if they can narrow down what they're asking for, or
Right.
say that the info is protected.
Like by privilege.
Exactly.
Okay.
But if that doesn't work,
Yeah.
and they still want the information, the psychologist can ask the court for help. So they might file a motion to quash the subpoena, meaning they want the court to say it's not valid,
Mm-hmm.
or they might ask for a protective order, meaning the court would limit what they have to disclose.
So they're like fighting for their client's privacy.
Yeah, it's all about advocating for the client while still working within the legal system.
Right. And the APA also talks about what to do if you're asked for confidential information
Okay.
while you're testifying in court.
Oh, yeah, that can happen.
Right.
And it can be a surprise.
So what do you do then?
In that case, the psychologist should say that the information is privileged
Mm-hmm.
and not share it until the court tells them to,
Okay.
which is consistent with California Evidence Code Section 1015.
Right. So they're protecting their client's information.
Exactly, unless a higher authority tells them they can't.
Right. So what if the court does order them to share the info?
Right, what if they try to fight it
Yeah.
and they lose?
Uh-huh.
Then the psychologist has to comply
Okay.
to avoid being in contempt of court,
Yeah.
which is not good.
Great. But even then, they should only disclose what's absolutely necessary.
Yeah, and if they have to give confidential documents,
Uh-huh.
they should seal them in an envelope
Yeah.
and mark it confidential.
Okay. So it's like they're trying to limit the damage.
Exactly, following the rules, but still protecting the client as much as possible.
Yeah. And I think this is super important.
Okay.
Our source says that destroying or changing records
Mm-hmm.
to avoid sharing them is illegal.
Yeah,
Big no-no.
yeah. So basically, you can't try to hide things.
No, that's tampering with evidence.
Yeah, and that's a whole other problem.
It's super serious.
So understanding how to deal with a subpoena
Yeah.
shows how carefully psychologists have to act when they're asked for their client's info.
It's a constant balancing act
Right.
between ethics and the law.
Exactly.
It's where those two worlds collide.
So to sum up today's deep dive, we've gone over a lot.
We have.
We talked about the difference between expert and fact witnesses.
We unpacked all the complicated stuff around privilege and confidentiality. We looked at informed consent in forensic evaluations.
Yeah.
We learned the legal definition of insanity.
Which is specific.
Very specific in what it does and doesn't include.
Yeah.
And we walked through all the steps psychologists take when they get a subpoena.
Phew, that's a lot.
It is, but I think it's important.
Oh, absolutely.
We saw how psychology is used in the legal system.
Right, and how important ethics and legal rules are.
And I hope you listening got a much clearer picture
I hope so.
of this fascinating world where these two fields intersect.
It's important to understand these things
Yeah.
if you want to know how our legal system works,
Right.
especially with these complicated cases that involve mental health.
Absolutely.
Right.
So, given everything we've talked about today,
Yeah.
and this like sometimes tricky relationship between a psychologist's ethical duties
Uh-huh.
and what the law demands,
It's a tough one.
it is. What do you think are the biggest challenges in making sure justice is served
Yeah.
while also making sure people are okay?
I think that's a question we all need to think about.
That's something to ponder
Definitely.
as we wrap up
For sure.
our deep dive today.
Absolutely.